Well, welcome to today's debate. Should the Constitution be interpreted in accordance with the original understanding of the framers? I should say that today's debate marks the college's annual observance of Constitution Day, the day on which the Constitution was finally approved in 1787. Believe it or not, Congress actually requires us as an educational institution to recognize Constitution Day every year, so we're doing so today.
That's unconstitutional.
That's not the issue for today. Now, we've done this debate two previous times between Professor Klarman and Professor Meese. And the first time we did it, the way we advertised it is we put the two of them in sort of a boxing pose to kind of set it up. And we tried to find that old photograph, but we couldn't find it. We used it this year, but we're not able to. But I am going to rely on sort of the boxing metaphor in introducing our speakers. In this corner, arguing the affirmative, is our very own Alan Meese, the Ball Professor of Law, who's been a member of our faculty since 1995. He teaches in the areas of constitutional law and antitrust law. Of particular note, Professor Meese served as law clerk to Justice Antonin Scalia, which goes to show that the apple doesn't fall far from the tree when it comes to constitutional interpretation. Now, in the boxing world, everyone has a nickname. You got Smoking Joe Frazier, Sugar Ray Robinson. So we're going to have to come up with one for Alan. Now, Alan, as it turns out, is a very big Minnesota Vikings fan. So in finding a nickname for Alan, I decided we'd go to the Vikings' great quarterback, Fran Tarkington. We'll call him Alan the Scrambler Meese. Now, in this corner, arguing in the negative, is a good friend of William & Mary Law School, Michael Klarman, the Kirkland and Ellis Professor of Law at Harvard Law School. Mike actually was our visiting Lee professor at William & Mary about 10 years ago, and has been back on many occasions. Professor Klarman is one of the foremost constitutional historians, I think, of our generation. Of particular note is his book From Jim Crow to Civil Rights, The Supreme Court and the Struggle for Racial Equality, which in 2005 won the Bancroft Prize as an outstanding book in American history. He's here today at the law school as our distinguished Order of the Coif visitor. Now, we need a nickname for Professor Klarman. Mike is a big Boston Red Sox fan. So as a tribute to that Red Sox all-time great, Ted Williams, who enjoyed a lot of different nicknames over the course of his career, we're going to call him Mike the Thumper Klarman. So we've got the Scrambler against the Thumper, and that may be an apt metaphor for today's debate. Each will have 25 minutes. Professor Meese will go first. He's going to reserve a few minutes for rebuttal, and then we'll throw things open for questions. So, Professor Meese, the Scrambler.
Well, thank you very much, Dean Douglas, and I'm glad you didn't choose Brett Favre, because then I wouldn't know what my position is, right? And I did used to have a Fran Tarkington jersey. So, just want to say how much I appreciate the opportunity to talk to you all today, and also very much appreciate the opportunity to debate with Professor Klarman. Dean Douglas said we've done it twice before, and we also did it once at UVA on a different topic, and I've always enjoyed the experience. So thank you again for coming down and being such a great friend of William & Mary. Okay, let's get down to brass tacks. What if Congress passed a law unanimously that outlawed the practice of the Presbyterian religion, and the President signed that bill into law? How should a judge evaluate a challenge to that law? There are 5 options I'd like to mention. 1, simply defer to Congress because we live in a democracy. 2nd, defer to the executive branch because the executive branch has a lot of guns, including the Army and the FBI. 3, read lots of law review articles and philosophy journals and decide whether the law makes sense in some moral or philosophical matter. 4, determine whether the law violates the Constitution of France. Or 5, dismiss the indictment, right, because the law violates the Constitution of the United States. It exceeds Congress's enumerated powers and also violates the First Amendment. But I think if given those options, most of us would accept and embrace number 5. We would say we live in a constitutional democracy, not in a pure democracy. We don't believe that power flows from the barrel of a gun. We don't think judges are platonic guardians who should decide cases by reading philosophy articles. And thankfully, most thankfully, we don't live in France. Instead, we live in a constitutional republic. And the Constitution is the only source of the government's authority in a constitutional republic. not articles in the Yale Law Journal, and not the Constitution of France. The American Constitution empowers Congress to do certain things, and also expressly prevents Congress from doing other things. And if Congress or the President exceed the scope of their authority, it's up to judges to strike down that statute. If they act within their authority, it's up to judges to enforce that statute. No questions asked. Now, if you choose option 5, like I just did, you are in very good company. Not with me, but with people like John Marshall, Alexander Hamilton, George Wythe, James Madison, Justice Scalia, Chief Justice Roberts, Justice Thomas, just to name the very most illustrious proponents of an original meaning approach to constitutional interpretation. Now you might say, well, no, wait a minute. I like option 5, it sounds good. Right? I believe in constitutional democracy. But does that really mean, right, that I have to adhere to an original meaning approach to interpretation? Can't I just say that judges should enforce the text of the Constitution, leaving open the question of how judges ought to go about enforcing that text or interpreting that text? Can't we separate our adherence to a constitutional democracy from our theory of interpretation? My answer to that is no way. Right? You can't do that. That notion of a non-originalist interpretive approach to the Constitution is incoherent, or a non-originalist textualism is incoherent. This is an effort to have your cake and eat it too, and it ignores a fundamental question, and that is, why is the text of the Constitution binding? Right? Again, selecting option 5 means you believe the Constitution is binding. There are all sorts of texts out there. Right? There's the Articles of Confederation, which purports to be a constitution, but we don't treat it as binding. Right? If French nationals lived in the United States and said, no, we're only bound by the Constitution of France, we'd laugh. Well, you're not bound by the Constitution of France, even though it says it's a constitution. Right? I brought my own constitution. Right? It's called the Constitution of Alan Meese. Article 1, Alan Meese shall not be taxed. Article 2, Alan Meese's salary shall be doubled. Article 3, the dean shall pay Alan Meese's salary daily in gold. That is a But he was out, he just proved my case. He proved my case. It's not a binding document, even though it says it's the Constitution. Okay, so what is it about the American Constitution, right, that Congress wants us to celebrate today, right, that makes it binding, right, compared to these other documents that I just mentioned? Well, John Marshall answered this question of Margaret versus Madison. Right? He said the Constitution is the work of the people, the supreme authority, the supreme repository of sovereignty, not just the representatives. By that he meant the ratifiers. And that those people had an original right, right, that is antecedent to any other political obligations, to establish for their future government, I'm quoting here, their future government, principles that, in their opinion, their view, the view of the ratifiers, not some other conception of natural justice, would conduce to their own benefit. He said these principles are fundamental, and they are designed to be permanent, not transitory. Right? They're designed to outlast the ratifiers. Right? This account from John Marshall, right, distinguishes the Constitution that we're celebrating today, right, from the other texts I've mentioned. Right? None of those other texts, right, was adopted by the people, right, the ratifiers of the United States. The article was adopted by the state legislatures. And this account distinguishes the Constitution from the Articles of Confederation, right, which said they could only be amended by consent of the state legislatures. But as Marshall explained in both Marbury and McCulloch, the people have the antecedent right to reject that approach because they possess the ultimate sovereignty in our national state. The Constitution is binding, according to Marshall and Marbury. Judges, like Congress and the President, are bound to enforce it. And when called upon to interpret and apply a statute, they must decide whether that statute comports with the Constitution. If it does, they must enforce it, whether they like it or not. And if not, they must strike it down, even if they like it. Now, you might say, that all sounds fabulous. What does it have to do with interpretation? Right? Shouldn't we figure out some way to interpret texts? I think that the answer to that question is everything. This has everything to do with interpretation. Unlike some legislation, the Constitution does not have a sunset clause. Right? It lasts until it's amended. As Hamilton said in Federalist 78, the Constitution is the document, the source of authority for the various branches of government. The Congress, the President, and the courts have whatever authority they have because the ratifiers gave them that authority. Each branch, when it purports to act pursuant to the Constitution, that's the only source of governmental authority here that I know of, right, has to decide whether they're acting within those boundaries that the ratifiers set. And therefore, they have to determine the original meaning that the ratifiers gave to those provisions. What were the opinions of the ratifiers, as Marshall put it, right? That the ratifiers made permanent because they thought those were the best ways to govern our future state. You can't both say, I derive my authority from the Constitution of the United States because the ratifiers gave me that authority, and then declare that you can simply ignore the meaning that the ratifiers gave to that authority as though it's some kind of historical artifact. Right? If you take this latter approach and you depart from the original meaning,